see how we unring the bell, how the jurors unhear what they heard, and I don't know how the court cures it without bringing more attention to other issues. I mean, I thought the state was all concerned about talking about punishment and penalties and stuff. I thought this was an issue we discussed before trial, and I don't know how the court addresses this to the jury without bringing attention to punishment issues in the case. It's just unfortunate, and obviously it was arguably intentional in the question itself. It wasn't, we've already heard a statement, it was not an accident, it wasn't a misspeak of words, it was intentional, and we think that a mistrial is the only remedy under the circumstances.
From the other defendants on the motion.
We are waiting to see what you do about our motion to admonish and a curative instruction.
I agree with Ms. Hogue.
From the state.
We leave to the discretion of the court.
All right. Yeah, the court indicated that I'd take the lunch break to think through exactly what to do. The court does find that the question that was presented was inflammatory and irrelevant and completely unnecessary, particularly given the witness that was on the stand. It has potentially injected into this case issues not appropriate for the jury and which were in fact discussed and brought up pre-trial. Counsel should have either known or should have known that this was a question that should not have been asked, and therefore counsel is admonished by the court and is instructed not to repeat such actions subject to the contempt powers of the court. The court does in fact, or will, instruct the jury that the state has been admonished based on the question. I'm not going to repeat the question. And I'm going to instruct them to disregard the question asked and any implications arising therefrom. That is the intent of the court. The motion for mistrial is going to be denied, with the court finding that the admonishment is the appropriate remedy and the instruction to the panel addresses the matter presented.
And just for the record, Your Honor, the court's going to do this in front of the jury, and I just don't want to be perceived as having waived by failing to accept. I'm just putting on the record that we do not believe the curative instruction will be sufficient. If the court wants me to come back up and say that again after the court actually does it, I can do that, but in the interest of efficiency, I'm just asking if the court will recognize this, preserve the motion for mistrial notwithstanding the curative instruction, or does the court want me to get up again and renew it after the curative instruction?
As far as the court is concerned, the court's ruled on the mistrial, and I have, I guess, pulled the motions together. I am providing, I've admonished the state, indicated the court's position with regard to the question, indicated that the contempt powers of the court would be the next remedy available if such action was taken, and I will indicate to the panel that the state has been admonished as such and instruct them to disregard the question. So that addresses both the motion from the McMichaels as well as with the court denying the motion for mistrial will instead be providing the instruction that I have just indicated.
Thank you.
Anything from the state before we continue? Actually, it's the defendant's case, Chief. Anything from McMichaels before we continue?
We're ready, but I think Gregory McMichael.
Yes, Your Honor. On behalf of the McMichaels, I'd like the court to either revisit or think with outside the presence of the jury about a ruling on an objection made earlier concerning the use of Facebook posts with defense witnesses. The Facebook page that is informing the residents of Satilla Shores, including Travis McMichael, is relevant in this situation. And here is how. We didn't have the opportunity to argue this for Your Honor. Travis McMichael took the stand. He testified that he was informed by a number of sources about crime in the neighborhood, and that one of those sources was the Satilla Shores Facebook page. The Satilla Shores Facebook page is something that the state had acquired early on and had been provided to us in discovery. The Satilla Shores Facebook page has been something that was used on cross-examination of Travis McMichael, and the question before the jury as to whether or not this neighborhood had been experiencing an uptick in crime is relevant to the issues the jury will have to resolve, because it goes to one of those factors concerning the totality of the circumstances. What did Travis and Greg know at the time they made the decision to do the things they did, to choose to be proactive instead of, as the state has asked Mr. McMichael on the stand, just choosing to stay home or call 911. Additionally, the state has continued to argue through evidence and GCPD and GBI agents that it really wasn't all that bad out there. So, Your Honor, prohibiting the defense from questioning Satilla Shore residents who were involved in posting or reading Facebook posts on the Satilla Shores Facebook page, and who will testify that what they saw and either posted and read informed some of the choices and decisions they made about their own liberty and their freedom and their safety and security, is a relevant inquiry for this court now that we know and have had a witness to say that Travis McMichael saw the page, that his mother would see the page and would talk to him and his father about it. For that reason, it would be just like excluding any questioning of a witness about something she read in the Brunswick News. The Brunswick News says, hey, a serial killer has just escaped from the Brunswick jail, the Glynn County jail. Everyone lock your doors. Well, maybe it's right, maybe it's wrong, but it sure does inform the decisions they make and the thought process that they have. For that reason, Your Honor, so long as the proper foundation is laid, the defense contends that we ought to be able to question and allow our defense witnesses to testify about things they saw, things they posted on Satilla Shore Facebook page, and how those things they saw and posted informed their decision making.
Anything from the state?
Yes, Judge. First off, Travis McMichael was shown Facebook posts that he made, and that he responded to, and that he commented on. So that doesn't really go to that argument. The problem here is, how is it connected to Travis McMichael? Travis McMichael testified appropriately that I looked at Facebook and I thought there was an uptick in crime. That's his perception, that's his opinion, and that's before the jury. So that's fine. But putting Miss Lindy Cofer up, which they just did, who said, I've never been the victim of a crime, and yes, I would repost other people's things on Facebook, there's been no causal link between what she did and her Facebook postings and Travis McMichael. There's been absolutely nothing that connects the two of them that makes it relevant. And her perception and opinion, now, if she had taken the stand and said, yes, I saw a Facebook post and I went out and put up cameras, or I was the victim of a crime and put up cameras in the neighborhood, as we assume some of the witnesses are going to testify to, yes, that's what that person did. But to solely go, I read Jenny's Facebook post and Stevie's Facebook post and this other person's Facebook, and this is what they said, well, that's hearsay. And that's basically not admissible evidence at that point. So I'm not sure what the defense is asking for these witnesses to do. I think at this point the suggestion is, we see if it's hearsay, we see if what the person's talking about is their personal Facebook post, or is this something they read, because we're going to bring in every single Brunswick newspaper and show it for all of 2019 and 2020 to inform these people. They all read the newspaper. Maybe they watched the nightly news. How does that connect up to whether it's more likely or less likely that the defendants committed the crime? So we ask it to be more on a play-by-play basis, because I think that's the appropriate way to approach this.
Agree with that, except let's see if we can all agree on the definition of hearsay. Hearsay is not a Facebook post if it's not being offered for the truth of the matter asserted, but instead to inform an individual who has read it or posted it, and who will do, just as you said, Ms. Donikoski, will testify about how that affected one's perception of their neighborhood and may have caused them to take certain additional safety measures or constrain their own liberty as a result of what they've read.
Yeah,
Now, your facial expression makes me think that we're not on the same page about
I'm
your
trying to
safety.
figure out how to explain where I am on it. The objection that was made during the last witness, the court sustained the objection and actually explained the ruling. She was asked generally about, I didn't write it down, but generally about Facebook posts and what her thoughts were. But my ruling, I indicated that I think it was a relevance objection, was not relevant to the defendants and what they may have known, and none of that got linked up. So for that particular objection, if I remember correctly, that was the basis for it. The challenge with the Facebook posts is it's social media. I'm not sure exactly what the basis of it is. There are some issues that are out there, so the court has some concerns about a bunch of Facebook posts being the basis for anything. But more importantly, what we're here about is what the defendants think was going on, as opposed to with the last particular witness, what a resident of 30 years may have seen and how she reacted to it. The court has some concerns about the relevance of that evidence, and I'll rule on it accordingly. But just putting up individuals that live in the neighborhood and say, I looked at Facebook and this is the way I felt, I think that there's the basis for some objection there, and I'll go ahead and take that as they come. But if it can be linked up with what's actually before the court, so be it. But just bringing witnesses in to say they looked at Facebook and unrelated to, in fact, she testified, I think she didn't know the defendants.
That's
correct.
Yeah. And I'll just say this last piece, Your Honor, to fill in that one gap. We will link this up. And I think it's important for the court to be reminded that during the cross-examination of Travis McMichael and other direct examinations of GCPD and GBI agents, the argument has repeatedly been made by the state that the defendants are exaggerating the feelings of that neighborhood and what was really going on in that neighborhood. So I think the only way to respond to that, if I'm acting on behalf of myself and my neighbor, then it's fair enough for me to say, well, let me tell you what my neighbor was worried about. Here's what she told me. Here's what she experienced. And that may help the jury think more clearly about the way that the state is characterizing a peaceful, calm, placid Satilla Shores in February of 2020.
I just want to add, I'm sorry. I just want to add, I think Ms. Hogue addressed it, but several witnesses have testified that there were maybe 2 burglary 911 calls or 2 entering auto 911 calls, 1 burglary call for this long period of time. That testimony was elicited by the state. The only way to respond to that, there was more crime in the neighborhood, is from people who experienced it and read about it and were concerned about it. And that's the relevance of the Facebook page, because Travis McMichael testified on direct.
Well, let me just, I guess I was going to say, I don't mean to cut you off, but I'm going to do it anyway. Yeah, I mean, if you've got a witness that stands up and testifies that they were the victim of a crime in Satilla Shores, sure. But if you got a witness that gets up and says, oh yeah, I lived in Satilla Shores and I looked at a Facebook page and I used that to inform myself about crime in the neighborhood, but I've never spoken to the defendants, which is exactly what we had with the last witness, that's an objection that's going to be sustained. Those are 2 very different things. Okay. All right.
I mean, we believe, because of Travis McMichael's use of the neighborhood Facebook page, as a source of information that raised concerns that he testified about.
Well, and he testified, and on direct could have walked all the way through that. So and I believe he testified to what he was informed of in the neighborhood, and Facebook was referenced during his direct examination.
Correct. And this corroborates that there were, in fact, Facebook posts about crime in the neighborhood.
But
from the.
I'm not going to debate it. The question that went beyond that into what the Facebook posts were, and so again, the objection was sustained with the last witness. I've explained where the court generally is on this, and we'll proceed from there. All right, we're going to bring the panel in. I'm going to provide the instruction to the panel, and is Travis McMichael ready with his next witness?
Next
Or
witness
his next
is
witness?
Cindy Clark.
For the record, on the recess for lunch, we had a individual out in the foyer of the courthouse wearing a Black Lives Matter mask, bringing to the court's attention, for the record.
Okay. All right, let's go get the panel.